The debate analysed centres on the events happened in Kenosha on August 25, 2020, where Kyle Rittenhouse allegedly crossed state lines to defend private property from rioters, and being in the possession of an illegally detained firearm, ended up killing 2 protesters. For the purpose of the discussion, both debaters are essentially assuming that 1. The people that Kyle killed assaulted him first.
The very first video we see is Kyle being chased by one guy, Rosenbaum. The guy eventually throws something at him, and then Kyle turns once the guy's within arm's reach, and then shoots him 4 times, I think. That's the very, very first shooting that we see.
Okay. I won't dispute that. That sounds about right.
2. It is morally justifiable to defend valuable private property with firearms.
The property argument, I think I fundamentally agree with you on that front. I think that you brought up the LA riots as an example and talked about there's some instances where if you have a marginalized group of people who want to defend their property against a bunch of racist ass motherfuckers, that they should be able to take up arms in order to do that. I think I fundamentally agree on that, so I won't waste too much time on that front.
3. It is a positive utility action to defend oneself from an assault with any means possible.
If someone reasonably believes that someone else is going to kill them, regardless of whether or not that person is actually going to kill them, I think that affords moral latitude to be able to use deadly force in self-protection.
Okay.
So I won't get too bogged down there.
Destiny thinks that although Kyle committed some negative utility actions, he is not to blame for the loss of lives that occurred, while Riley thinks he is. Riley states her case.
I start with the premise that allowing certain people to open carry firearms itself increases the risks of death or grievous bodily injury, according to academic consensus. This is the likely policy basis for the Wisconsin law against open carrying of a firearm for people under the age of 18. From there, Kyle Rittenhouse knowingly and openly carried a lethal firearm at the BLM event. From there, Kyle Rittenhouse either A, knew about the law and chose to disregard it, or B, did not know about the law and acted negligently in choosing to not check it beforehand. From there, 5, by choosing to either consciously disregard the law or negligently disregard the law, he also disregards the policy basis for that law. And by disregarding the policy basis for that law, he assumes the risks associated with disregarding that policy, namely that using his firearm could result in the death or grievous bodily injury of another person. So, if Kyle were to find himself in situations where he may otherwise have had a reasonable belief that he needed to use a firearm, by assuming the aforementioned risk, he would have actually and proximately caused those situations to arise in the first place. So when he killed or caused grievous bodily injury to other people using his firearm, I would say he both actually and proximately caused those outcomes by assuming the risk of having a deadly weapon, despite the policy position that Wisconsin law is based on, and that therefore he is morally culpable for the deaths that he caused.
The argument appears valid. But even if an argument is valid, it may not be sound. Destiny argues that this argument is in fact unsound. And to prove it, after attacking some of the premises,
we're relying really heavily on some relatively arbitrary definitions of what is the age of majority. I don't know if I fully buy that, if you are aware that a certain law exists, that you necessarily agree with all of the underlying, moral implications behind that law.
He searches for a counterexample. That is an example that would fit all the premises, but applying the same conclusion would be wrong. In fact, if such an example could be found, then it would imply that the argument of Riley would be unsound, since we have granted that the argument is valid, and a valid argument with true premises cannot lead to a false conclusion. Destiny constructs his counterexample.
Let's say that you have a state. The law is you need to be 18 years old to drive. That's the law. Let's say that there's a kid, so super common. A lot of kids that grow up on farms learn to drive as early as 9 or 10. It depends on when they get their growth spurt. They can see over the steering wheel. They learn to drive trucks and stuff on the farm very, very early. Let's say that you have a guy that's been driving trucks across the farm for 7 or 8 years. Okay? Let's say that this kid is 17 years old. State law says you need to be 18 to drive. But let's say that, he feels like he's driven enough on the farm, whatever. He's going to drive into town and he's going to pick up groceries with his sister. Let's say that as he's driving into town, let's say that he comes up to an intersection and he goes to drive across. The light is green, he's got the right of way, everything's fine. And in a totally unpredictable manner, a drunk driver comes swerving out of nowhere and almost collides with him in the intersection. Or rather, let's say he collides with him in the intersection, and let's say that his sister is killed in the passenger seat. Since he was driving and he was underage, is he morally culpable for his little sister's death, despite the fact that that death happened at the hands of another aggressor, and he didn't really do anything wrong, save for breaking the law of being an underage driver?
But Riley argues that it does not fit the premises, since...
So the problem with this is that I think that there's one major thing that kind of distinguishes this from the facts that we're discussing, and it's primarily that there is that there's not a risk, or there's not like such an overbearing risk associated necessarily with driving in the same way that it is with handling a firearm. Like, it is something which is explicitly used to cause death or grievous bodily harm. Like, that's the point of guns, unless you're using it for sport, and I don't think that anyone is arguing that he was using it for sport here. Whereas cars have such a like wide latitude of uses, right?
Whereas like a car, when you're using that, your express intent is not to harm people. I think it's like completely different.
Although nowhere in the premises is it stated that the expression of intent of carrying a firearm is relevant to the argument. These kinds of things happen in a live debate, since it is hard to recall exactly what one's initial argument was. Ideally, what Riley should say here is, I have misstated my first premise. What I meant to say was that firearms express intent to cause violence, and they escalate situations. This fact increases the risk of death or grievous bodily injury. And the debate could continue from there. Luckily, both debaters understand that the argument under consideration has changed. With this new argument, Riley is in fact correct in stating that the counterexample found by Destiny would not satisfy all the premises, because driving a car does not express intent to cause harm. So the discussion moves on. Some of the premises are again questioned, and finally Destiny produces another counterexample.
Do you think that any protester out past curfew, it just needs to accept whatever harm comes to them, and they don't really have a basis by which to defend themselves, since they're breaking the law of being out past curfew?
Not only is this a counterexample, but it also refers directly to the case at hand, a pretty rare occurring. Having understood Destiny's point, Riley leaves the debate honorably questioning her argument in a show of good faith.
I have to think more about it. I mean, I could see an interpretation of the premises I've laid out that would make those people morally culpable for the harm that might cause them. Now, I would say that there's probably a problem in the law, and that, the law is fundamentally operating against the interests of those protesters who might want to push some other kind of action. But this is something I'd probably have to think more about.
More property damage, more arson, more harm, and more violence probably occurs past curfew when it starts to get darker outside. So it seems like protesters that are violating curfew are standing in opposition to a law that exists for safety. So then I wonder, if they were to be attacked at night and then act in self-defense, are they going to be held to the same standard that you're holding Kyle to, because they seem to be violating a safety law for no good reason?
Without further context on it, I mean, I think I agree with that. I think I agree with that interpretation. Again, I'd probably have to think more about that implication, just because I haven't considered this before you said it, but I think that lines up, right?
This is arguably harder to do than actually defeating an argument, and it shows great moral character. The debate analysed was one of substance. Few, if any, logical fallacies or rhetorical tricks were made. The debaters were charitable with one another, and both the argument and the rebuttal to the argument were laid out clearly.